Mr. Brennan.
Good morning, Your Honors. My name is Attorney Paul Brennan.
Good morning.
And I represent the defendant appellant Karen Alfonso. I suppose Your Honors expected me to come today to defend what's probably many consider to be an anachronistic statutory language, and that's certainly the argument of the Commonwealth, that the provision in Section 24A relating to the 28, excuse me, relating to the sentence appeals to the appellate division of the Superior Court as it pertains to appeals from to sentences to the reformatory of women has in effect been repealed by the truth in sentencing laws because there are no more reformatory sentences.
But do we have to even get there? I mean, your client was sentenced to a 3 to 5 year sentence to MCI Cedar Junction. That's the state prison.
That's correct, yeah.
To be served at MCI Framingham. That's really not. The fact that it's going to be served at one place or another is quite irrelevant to whether the sentence was a state prison sentence.
Well, with all due respect, I contend, and based upon the authority of this court in the case of Moulton versus Commonwealth, that a female could never receive a state prison sentence if she was sent to MCI.
Well, going one step further from Justice Cordy's question, aren't references to places to be served really superfluous anyway? Because isn't the Department of Correction in control of where the person is placed? I mean, they could theoretically have put this woman in jail, I suppose.
The department, yes, but the Commissioner for Corrections does have power to move an inmate from one facility
right,
to another.
So the language, possibly the judges shouldn't even say that anymore, and it's just superfluous, and we should read it out of the sentencing because it has no meaning.
Well, with all due respect, the precedent is that a sentence to MCI Framingham, that a female convicted of a felony under Chapter 279, Section 19, has to be sentenced to MCI Framingham.
No, it doesn't
So
say
it
that.
doesn't have to be sentenced. It has to be served there because there's no other place to serve it.
Well, the Moulton decision says, that in effect, that means that she has to be sentenced to Framingham, and that is not the equivalent of a state
But Moulton
sentence.
was based in large part on the fact that there were independent budgets, which there certainly aren't today. There's no independent budget for Framingham.
Well, I don't think that I don't know that, Jan. I have the Commonwealth's word for it in its brief, but there's no. But be that as it may, I don't think that was the only consideration that the court gave in Moulton for determining that a sentence that a female could never be that a sentence to MCI Framingham is not the equivalent of a state sentence.
But the whole statutory scheme, the sentencing scheme, is very different today than it was at the time in Moulton.
Well, Your Honor, with all due respect, I would say that until the time of the repeal of the reform sentence scheme, it was pretty much the same. In fact,
if we rule in your favor, no woman who was sent to Framingham from the Superior Court can seek relief in the appellate division.
That's not correct, Your Honor. What happens is that if a sentence is to Framingham for more than 5 years, yes. That's
right.
what.
I'll revise that. Under 5 years, no woman can seek relief.
Yeah, that's correct, Your Honor. My client is now saying that the appellate division of the Superior Court could not hear her case because she was sentenced to 5 years, in effect, to MCI Framingham. A judge did not have the power or authority to sentence her to state prison.
Well, wouldn't that raise equal protection problems because men can and women can't, if we accept your argument?
Well, if my argument is correct, that raises a very difficult question, Your Honor, which was not considered by the motion judge below. I would, however, point out that this court, in the case of I believe it was DuPont versus Commissioner for Correction, which was decided by this court last February, went into a lengthy analysis about equal protection as it pertains to male and female.
Equal protection isn't raised in this case.
Well, the Commonwealth raises it.
Right, Commonwealth raised it, which in fact it was quite strange, which to me is very opportunistic. I would assume that the obligation of the Attorney General's office is to argue for upholding the constitutionality of the laws of the Commonwealth, not to opportunistically.
Well, he gives us several reasons why we can uphold it on statutory grounds, and we won't have a problem. I mean, why we can interpret it differently.
Well, if I may get back then to the statutory scheme that which Your Honor referred to. My contention is that until the enactment of the truth in sentencing laws, the statutory scheme was pretty much the same from the time of Moulton until then.
But now it's different.
That's true.
Right.
So the question.
And the case we're faced with is now.
So the question then is, if by the enacting the Truth in Sentencing Law, does that in fact, therefore repealing reformatory sentences, does that in effect repeal the decision?
Well, of course, the decision
This
decision interpreted a statute. That statute doesn't exist anymore. There's no reformatory anymore. I mean, how can we say that women can only be sentenced to a reformatory? We said that in 1913 when the statute provided that, and now there's no reformatory, and Framingham is not a reformatory. It's a correctional institution.
Your Honor, if you direct your attention again to Moulton, they were interpreting Section 19 of Chapter 278. And in that case, it said, the court held that that every woman convicted of a felony must be sent to Framingham, and the court held, therefore, that means the reformatory for women. Okay,
that's because Framingham was at that time a reformatory for women. It's not anymore.
Well, it's just been a name change. There's no statute that says reformatory for women has been abolished. It said that what happened was that in 1952, in some sections here and there were changes in the nomenclature from reformatory women to MCI Framingham, but it didn't say that reformatory for women is abolished. And in fact, if you look at the reformatory sections, the section pertaining to reformatory sentences, the sections 16 and 17 of Chapter 279, the name reformatory for women was in that statute until 1972. It was only
but it's not now.
It doesn't exist today.
I'm sorry, Your Honor?
You agree that the reformatory for women does not exist today?
Well, I respectfully submit that the reformatory for women doesn't exist today in this sense, that the name has changed to MCI Framingham, but the particular institution that was created is still the same.
Can we agree, Mr. Blennon, that that what the legislature did at a minimum was to abolish reformatory
Correct.
sentences?
I agree with that, Your Honor.
So they abolished reformatory sentences. And the question is, when they abolished reformatory sentences, did that render no longer applicable a sentence, a proper sentence, not a reformatory sentence, to the reformatory for women?
Exactly, Your Honor. This is the heart of the matter. I agree with you. You got to the heart of the matter. And I would like to say, with respect to that when the legislature enacted the Truth in Sentencing statute, which is really, it's not a general statute. It was just a special statute amending ones, basically filling the knobs here and there. But it never said while it did specifically repeal the statute pertaining to reformatory sentences, it never said that females could be sentenced to state prison. And that is important because it's a rule of statutory construction that the legislature is presumed to know prior decisions of this court interpreting the law. And so when the legislature abolished the reformatory sentences, it did not necessarily mean that a female could be sentenced, be given an indeterminate sentence under Section 24 to state prison.
Well, it's very funny that you quote Moulton, because Moulton has a sentence in here that says, if, however, it is true there is no express repeal, if, however, a prior statute is repugnant to the subsequent act, the presumption is that the latter statute is intended as the final expression of the legislative will, and the former statute is necessarily repealed by implication. And I'm reading right from the Moulton case. And isn't that more or less what we have here? We have the legislation in the 1990s that repealed the reformatories in toto, and they just didn't repeal this statute. But this statute is now repugnant to what we now have. So there's a repeal by implication.
With all due respect, I don't agree that it's repugnant. I mean, it may be anomalous. Anomalous it may be.
At least inconsistent, because we don't have a reformatory.
The nomenclature It's the nomenclature. I think Your Honor's getting stuck up in the nomenclature. The reformatory for women is now the MCI Framingham. That was enacted.
I beg your pardon. I'm not stuck up on nomenclature. That's what your whole case is about. This whole appeal is because of nomenclature.
That's correct, Your Honor. And it was changed. And I think it was in 1952. It said the MCI, the reformatory for women shall now be known as MCI Framingham. That's all it said. It didn't abolish it.
No, but it changed. The whole sentencing scheme was changed, and the types of the prisons and the types of sentences were changed even.
But not until 1994, Your Honor.
Can a Superior Court judge sentence a woman to Framingham for terms of like 3 to 5, or does it have to be for a fixed term?
A fixed term, Your Honor.
Where do you get that?
Well, because the indeterminate sentence under Section 24 apply only to state sentences.
So they have to be sent for 3 years, 5 years,
That's
whatever
correct.
the
And
fixed
then,
term
well,
is.
You're saying that a woman cannot be sentenced to a state prison sentence.
That's correct, Your Honor.
And you
But in
find
this-
you find that where in our law?
I direct Your Honor's attention to the case of Commonwealth versus Graham, which gives if I may get the site, please.
In fact, in this case, the woman was sentenced to 3 to 5 at Framingham, which, as
That's
far
correct,
as I
yeah.
know, is the typical
No,
practice.
no, she was sentenced to state prison to be served at Framingham.
Yes,
3 to
but the
5.
sentence was 3 to 5. It wasn't a set number. It was a minimum and a maximum.
That's correct, Your Honor. But my
That's
contention is that because, but it's also a rule of statutory construction. This court cannot supply words that the legislature didn't put there. If the legislature did not see fit to abolish, to say that women can be sentenced to state prison, when there were prior decisions of this court interpreting the statutory scheme as
Interpreting a completely different statutory scheme from 100 years ago.
Well, Your Honor, when the Truth in Sentencing statute was enacted, it still did not say that women could be sentenced to state prison.
You're saying
Well, are you saying then that any woman who's in state prison has been sentenced there
Illegally?
unlawfully? And
Well, they're not in state prison, they're Framingham,
Can't
but
be
I'm
there.
saying that the sentences that they receive, these indeterminate state prison sentences are illegal, yes. But what I respectfully suggest that the proper sentencing structure is like a woman. If you get a House of Correction sentence, you get a definite sentence.
So,
And your parole eligibility is set by at discretion of the parole board. The parole board can set parole eligibility. I respectfully suggest
if we got some women down in Framingham, which we surely have, that
Yes.
were sentenced in this fashion, and went to the appellate division and got their sentences reduced, but they're still at Framingham, we're going to have to bring them all back and resentence them.
well, if they ask to be brought back, I don't think they would be, Your Honor. But in this,
Because the sentences are illegal.
well, if Your Honor, I can only speak for my client. I'm just saying, in my particular case, I'm suggesting that a
Well,
sentence.
I'm trying to find the implications of this.
All I can say, Your Honor, is that under this. The proper way to sentence a female is to give her a definite sentence, and then the parole
I
board
understand
determines
that. Let me ask you this.
eligibility.
Was that equal protection point made in the trial court?
No, Your Honor. There was a.
So why are we talking about it here? You say it's raised on appeal. If it
Well,
wasn't raised
the
it wasn't raised in the trial court, where I thought it wasn't raised, it's not before us.
Well, as the Commonwealth has raised it in its brief, Your Honor, I only addressed it because the Commonwealth has
But
raised
isn't
it.
that the short answer to it?
I'm sorry, Your Honor.
Wasn't raised in the trial court. That's the
Oh, well,
short
I agree.
answer.
I mean, I don't think the constitutionality is before this
But if
court.
we interpret the statute your way, and interpreting it your way, we create an equal protection problem. We would have to reach it because we can't interpret a statute.
We reach it in the next case when someone actually argues.
Well, yes, so Your Honor could say prospectively we think this might be unconstitutional, but as far as my client's not claiming it's
Did
unconstitutional.
you argue below that your client should have received a definite sentence, a one-number sentence?
I argued below that the sentence was illegal because she could not be sentenced to state prison. I didn't say argued.
Okay, you never argued below that this should have been a straight 5-year sentence.
No, Your Honor.
So that's not before us
Well,
either.
Your Honor asked me apropos what the proper sentencing scheme should be. If she was sent back for resentencing, I would respectfully submit it would be a determinate
But
sentence.
you aren't asking for resentencing. You're simply asking that you're simply claiming that the appellate division had no jurisdiction, so she should go back to her original concurrent sentence rather than on and after.
I think, Your Honor, if Your Honor found that my argument was correct, you could order for remand for resentencing.
But that isn't what you asked for.
Well,
Well, we could.
we could, Your Honor.
I think we got it.
Thank you.
Mr. Brennan. Mr. Levitz?
Randall Ravitz for the Commonwealth. The Superior Court properly denied Ms. Alfonso's Rule 30A motion. The language at issue here refers to a type of sentence that no longer exists. Even if this Court were to conclude otherwise, it should find that the restriction on appeals by females sentenced to terms of 5 years or less within that language should be found impliedly repealed. And if it were to reject either of those two interpretations, we would be left with a situation where Section 28A denies females equal rights of appeal to males, and it would therefore offend several canons of statutory construction.
Do you agree that there are no longer any sentences to the reformatory for women?
That's right.
So the fact that certain sentences to the reformatory for women can be appeals, can be brought to the appellate division is all very interesting, but it's irrelevant because they don't exist anymore.
The language is meaningless.
So why do we talk about reformatory sentences? Why didn't the legislature say they shall no longer,
They did. That's what they did in the 1994.
Wait a minute. Chapter 279, Section 16 says that a female may be sentenced to the MCI Framingham. You mean a judge cannot give a woman a 2.5-year sentence or a 3-year sentence to MCI Framingham?
A judge can give such a sentence, but it would be a state prison sentence to be executed.
But could you give the equivalent of a House of Correction sentence to MCI Framingham? Can you give a female not an indeterminate sentence, but a definite sentence of 2 years to MCI Framingham? Because Chapter 279, Section 16 says that a female may be sentenced to MCI Framingham.
Right. It would be a House of Correction sentence, though. So the answer is yes, but it would be a House of Correction sentence. It wouldn't be a reformatory sentence.
And under Chapter 279, Section 19, the statute says the sentence to imprisonment of a female shall be executed at MCI Framingham. Now, does that mean
that's Section 19?
Excuse me. Does that mean that if a woman gets a woman may get a state prison sentence, but it will be executed at MCI Framingham?
Has to be executed.
That's right. It would be executed at the building that's called MCI Framingham.
Yeah.
But it's a state prison sentence as far as the type of sentence.
In Chapter 279, Section 24, the indeterminate sentence to state prisons doesn't say that only men can get a state prison sentence. It says any convict who gets
That's correct. That's correct.
Do you agree that, or don't you agree, that the words in the judge's sentencing order are just superfluous? He could have said, and probably he should have said, although I know it's the standard to say the other way, should have just said, sentence to 3 to 5 MCI Cedar Junction, and then DOC decides where she serves.
That's right.
So
if the judge had said that, it would still be the case.
So we
that
could
why
direct.
doesn't the judge, I can't remember if it was a male or female sentencing judge, just say to be served in 3 to 5 to be served in a state prison?
Apparently, judges have been, for a number of years.
You don't want to send a woman to Cedar Junction. You don't want,
Right.
You want to sentence, you want to make clear whether you've got a state prison sentence.
But that is a sentence to Cedar Junction. The statute defines a state prison sentence as a sentence to Cedar Junction.
Exactly.
So the judge could have just stopped 3 to 5 at MCI Cedar Junction, period.
That's right.
And probably should have, although I know the practice is to go on.
Maybe yes, maybe not, because the judge probably is also looking at 279, Section 19.
Well, it's a practice that judges have been doing for years.
It's a practice that may be required by 279, Section 19.
Do you know if women such as this woman once they're sentenced in this fashion, are processed at Cedar Junction, or do they go directly for processing to Framingham?
I believe they go to Framingham. But we would submit that this is analogous to a situation where a judge sentences a man to MCI Cedar Junction, and he ends up serving the sentence elsewhere. And in those cases...
But we don't have... What's different here for women, I take it, is 279, Section 19, at least when you've got a felony, which is, presumably most of the state prison sentences, if not all, says, shall be executed in the Massachusetts Correctional Institution in Framingham. You don't have that for men. If you define the state prison as Cedar Junction, fine, that's okay for men, but the legislature said, but for women, it's got to be...
But it used the term executed at.
That means
so,
served.
So it's not describing a type of sentence.
No, I understand that, but I'm saying why judges may put that in because the statute requires it.
The Corrections Department is not even bound by that, are they? If they got this woman or some other woman similarly situated, and they decided she might do better in a house of correction environment, some houses of correction take Framingham inmates, I think. In fact, I know. They could move her to a house of correction, could they not?
I'm not certain about that.
But they certainly could move her to another facility out of state, and very often do if there were a danger situation, despite the fact that the judge says 3 to 5 Cedar Junction to be served at Framingham. If DOC decided for her own safety or anybody's safety she had to go to New Hampshire or Texas, she would go, and nobody would ever...
Yeah, so I guess what I'm leading up to is maybe the judge's language is superfluous. The sentence, in fact, was as suggested, was to MCI Cedar Junction. He was thinking, well, I know DOC is going to put her in Framingham. They have to. I know they can put her in a house of correction, perhaps.
I don't think they can
move
put her in
her.
a house of corrections under 279-19, can they?
It's an administrative transfer.
It's an administrative transfer, and the fact that I know women are serving this up in Ludlow and Hampden County. They're just administratively transferred to serve their sentences. So we could treat his language as superfluous, really as a direction, but not a mandate.
Right.
To the commissioner of the DOC, in which case the sentence is okay, and we don't have to get into this web of ancient history.
Well, and certainly this appeal could be decided just based on the facts of this particular case. It probably would be useful to provide guidance to other attorneys who might be inclined to misread the statute, though.
Did you raise your equal protection argument in the Superior Court?
Our argument in the Superior Court was only based on the facts of the particular case, the language used by the judge.
Your equal protection argument is that we should construe the statute in harmony with the Constitution.
That's right, that men and women should have equal rights to appeal. And my brother's in the ironic position of arguing that his client, a woman, should have lesser rights to appeal than a male.
Well, because if you have equal rights to appeal, you also have equal rights to have your sentence lengthened, which is what happened in this case.
That's true, but it still wouldn't be equal.
I understand.
Right.
I mean, you usually take an appeal because you think you're going to persuade the appellate, of the division of the Superior Court to reduce it, and they have the authority and the power to increase it, which they did.
That whole appellate division is kind of funny business to be raising. I mean, it doesn't exist in any other court. I know it's been around a long time. Well, anyway.
If there are no further questions from the panel,
thank you, Mr. Mayor.
rest of our brief. Thank you.